that's meaningful. Their names are already known. They have already, unfortunately, Your Honor, this may be a digression, but in the case of Ms. Hampton, I must say that I believe that her dismissal and the way in which the court handled that dismissal is an example, a prime example, in fact, of where the court's on-the-record description of the dismissal decision and the rationale and the contemporaneous release, perhaps, of the transcript, sensitively redacted, if there are personal privacy issues there, could have avoided the kind of feeding frenzy that ultimately occurred, not only at Ms. Hampton's home, I might add, but at the homes and businesses of a number of other jurors, because as the court will recall, the court did not disclose which of the jurors it had dismissed. And so the press, as inventive as they are, were going about seeking to try to find out what juror might be being dismissed. So my concern with respect to those jurors is that what the court ought to be doing in that case is, yes, perhaps reviewing the transcript as quickly as the court is able to do, determine whether those transcripts contain any portions which do implicate a clearly unwarranted invasion of personal privacy, and make appropriate redactions of those transcripts at the time. And with respect, I think, though, to the other 6 jurors, Your Honor, those who have gone more or less fully public, Ms. Murdoch, Mr. Knox, Mr. Kennedy, Ms. Harris, Ms. Florio Bunton, and Mr. Craven, I think that it is doing no one a service, particularly the jurors themselves, the former jurors themselves, that is, to have their transcripts and the records of their dismissal proceedings kept sealed. Because what has happened, as the court well knows, is that a pervasive regime of rumor, speculation, and innuendo has taken the place of facts. And I think, Your Honor, too, that speaks to a second issue which we raised in our initial papers, which is the importance of the court actually articulating on the public record, and perhaps even in the presence of the jurors, the reasons for its dismissal decisions at the time those dismissal decisions are made. That is, interestingly enough, one of the salient aspects of the Fegan case that has just been cited to you by Ms. Lewis. In Fegan, what happened is that the court, in fact, disclosed on the public record what it is that why it was that it made a decision to remove a particular juror. And I think that practice, buttressed and bolstered by the practice of Judge Oderkirk during the much more communally sensitive Reginald Denny beating trial, where Judge Oderkirk contemporaneously released the transcript of juror dismissal hearings.
Ouderkirk.
Ouderkirk, I'm sorry. Where Judge Ouderkirk did that, Your Honor, he, I think, performed a public service, because he, even though the dismissals occurred during the midst of jury deliberations, he eliminated the possibility that there would be speculation or guessing about why it was that a particular juror had been dismissed and what the motivating factors were.
Do you know Judge Ouderkirk's present position on this issue?
He has not communicated with me, nor I with he, Your Honor.
I think he regrets that situation because that particular juror received death threats and was erroneously identified as being some other person, which resulted in problems with that other person. There were significant problems in the disclosure of that information.
Well, Your Honor, with respect to the jurors who have already been publicly identified here, misidentification is not a problem. And with respect to, I have no information one way or another, Your Honor, that would permit me to comment upon the other aspects.
Just a digression.
Yeah, but in any event, I don't know what the prosecution's view on the underlying motion is. But Your Honor, I think that the Fegan case, if they're going to cite it to you, has no bearing upon this issue whatsoever. It's simply the court's, as I understand it, the latest statement on the basic underlying issue of manifest necessity versus good cause and what might constitute that. But I think it is interesting, Your Honor, and I commend the court to footnote number 6 in the case, in which the court lays out, albeit with ellipsis, a 7-paragraph description of why it is specifically that this particular juror was dismissed. And, Your Honor, I must say that by contrast, what's happened in this case is that we have either seen a total absence of any description whatsoever in the case of Ms. Jeanette Harris about why she was dismissed. The court did not even state its usual dismissal for good cause found rationale. But with respect to other jurors, Tracy Kennedy, he is the only juror who has been dismissed from this case where both sides were solicited and acquiesced publicly here in open court to that dismissal, and the court found abundant good cause. Now, what was so different about Tracy Kennedy than about any other juror that caused the court to do that in that case and in that case alone? I don't know, but the problem is that the absence of the court's articulation of a rationale for that dismissal decision and for all of the other dismissal decisions is that the public has been left to speculate. And speculation, Your Honor, in the context of a public trial is just not what ought to be encouraged. And I think both the people under Proposition 115 and the defense under the Sixth Amendment and Article 1, Section 15 of our California Constitution each have a right to a public trial. And the cases that we've provided to the court already manifestly demonstrate that a clear component of a right to a public trial is the right to know what's going on at all stages of the proceedings. And if those proceedings are not such that the court feels comfortable providing access, although in some of the cases we've provided to you, the court will note that even in juror dismissal hearings, there have been courts which have concluded that the press ought to be physically present during those dismissal hearings, ought to have access to those to even post-trial investigations. But that's not what this motion is about. We're not here requesting that the media at this point or that the public be allowed into those hearings. What we are saying is that at bare minimum, what this court ought to do to ensure the public trial right is to contemporaneously, promptly as possible, release the transcripts of those proceedings and related developments.
Do you think I should at least require that notice be given to these jurors who have maintained, or at least a notice that unless I hear from them, that I'm inclined to release the transcripts redacted for personal information?
Well, Your Honor, I don't know of any case which has ever said that jurors ought to have some ability to control what it is that that is released about them and their conduct during the course of trial.
Or do you think dismissals for misconduct is sufficient to waive any right to privacy?
I do, Your Honor, I do. And we heard from Mr. Dershowitz last Friday that this is not, and I must accept the fact because I've not been privy to any of the transcripts. Mr. Dershowitz said last Friday that this is not the kind of case where dismissals are for typical reasons, illness, death, things of that character, extreme family emergencies. He has asserted, and I appreciate that the prosecution has contested at least to some extent, the fact that each of these dismissals is a dismissal for misconduct. And I think what that means, or at least what it says to me, is that when jurors are engaging in misconduct, they are violating a public duty, a public trust. They are violating their solemn oath to do what it is that you have instructed them to do. And I think when that is found, and when the court finds good cause to find that that has occurred, then I think there has been a waiver, and I don't believe that it is necessary for this court to make inquiry of the jurors.
I can think of one situation, two situations, where I did not make a finding of misconduct.
Okay? That all the more reason to release the transcripts, Your Honor. If a juror is being dismissed for reasons other than misconduct, and they are not, and I would hasten to add that even if they were being dismissed for what Mr. Dershowitz had characterized as traditional reasons, maybe there's some other reason other than misconduct or traditional reasons. But
no, we had two traditional reasons.
okay, if there are traditional reasons, I would suggest that there are ways of sensitively redacting the transcript of those proceedings to the extent that they really do trench upon matters that are private. And I would also suggest to the court, and this was something we suggested back in April when we initially wrote a letter to you on this specific subject, I would suggest to the court that when in the future it is, I hope it doesn't have to engage in the process of determining whether or not additional jurors are to be dismissed. But if that unfortunate eventuality should come to pass, then I would suggest that what the court ought to say at the outset of the proceedings is, look, to the individual juror, the transcripts of these proceedings are going to be made public, but they will not be made public until after you're dismissed. I think that's the way of remedying that problem on a going forward basis. Hopefully there won't be any need to deal with that on a going forward basis. But in any event, I appreciate the court's forbearance on this, and I would simply reserve the opportunity to respond to counsel with respect to whatever they may say about the Fegan case.
All right. Thank you, counsel. Excuse me, Ms. Sager. Good afternoon, counsel. Do you have anything additional to add?
Just very briefly, Your Honor, I think Ms. Mirell has covered most of the points. The only thing that I would say in addition to that is that the hearing last Friday is, I think, a clear demonstration, along with all of the other problems he raised, of the problems that arise from holding proceedings behind closed doors. You have serious accusations being made by counsel for the parties against one another, and the public is left without any knowledge whatsoever about whether there's merit to the accusations or whether the proceedings that the court is engaged in are fair, and the proceedings, as they ultimately will result, is a fair result. And all of this has resulted, I think, in some kind of taint on the proceedings, which can only be solved by releasing the materials and letting the public know what is going on. And that's precisely what the Third Circuit Court of Appeals indicated in the Simone case, that once the taint has been raised, that then it is critical that the public be advised of what's going on so that they are assured that a fair proceeding is being held. And whether or not, as you mentioned to Mr. Mirell, some of the jurors have not been released for misconduct, I would think that that would be an even greater impetus for releasing information to the extent the court can do it as to why they were released. Because if statements are being made in court, the jurors are being all released for misconduct, then I would think those individuals would have a concern about the public having a perception of them that is a false perception. And to the extent those have been released for misconduct, then the public should know that there is justification for those releases, and not that, as some accusations have been made back and forth, that they're being released for reasons other than good cause. And the public is vitally interested in this. I've received a number of calls, as I'm sure the parties have, and probably the court, with people saying to me, as one woman did last week from Northern California, what are they hiding? Why don't they want us to know? There must be something there. And for the same reason that voir dire is held in the open, so the public knows that a fair process is being held and the result is a fair result, I think it's equally important that the public know when a juror is dismissed what the reasons are for that dismissal. And I'd add nothing else, Your Honor. I think that the time has come for release of these materials. There's no reason not to release them at this point, and as opposed to waiting till the end of the trial or some future date, the jurors who have been released have already been the focus, as Your Honor mentioned, of a great deal of scrutiny, and if a further delay occurs before the release of the transcripts, they'll simply be the focus of additional scrutiny down the road. So it's not as if people are not going to wonder what has happened and why they've been released. If there's been misconduct, the public should know that. If they've been released for other reasons, the public should know that as well. So I would join in Mr. Mirell's motion and urge the court to release the transcripts at this time. If there's a need to redact because of some inherently personal privacy interest on behalf of one of the jurors, then only those portions be redacted that must be redacted, just as the standards for voir dire would have the proceedings completely open, but for any inherently private material that must be done in chambers. Thank you, Your Honor.
Mr. Dershowitz.
May it please the court, this is a triangular issue. The defendant has a Sixth Amendment right and the related California provision to a public trial. The media and the public and the ACLU have a First Amendment right, and jurors may have an interest in privacy. With all due respect, the state does not have any rights and probably doesn't even have a sufficient interest to give them standing to participate in this discussion. That perhaps explains why up to now I don't even know what the state's position is. When I asked what the state's position is, I was not told by the state, but then I was told by a representative of the media that the state will surprise us by coming in and opposing this request. I'm not sure the state even should be given standing to make any argument because in some respects it does not really involve any interests that they can specifically state. In very typical cases, there's a conflict triangularly between not the juror on the one hand and the public and the defendant on the other hand, but often between the defendant and the public. In many of these cases, the defendant does not want the transcript revealed, and then you have a constitutional clash, the First Amendment versus the Sixth Amendment, because the defendant can waive his Sixth Amendment right to a public trial within reason. In this case, the defendant most definitely asserts his Sixth Amendment right. He wants this case to be entirely open. He wants this proceeding to be open, as you know, Your Honor. He requested that he be present. That has been turned down. That's for a different time and a different day. But he wants the public to know what went on there, and for a very important reason. In my experience, Your Honor, in more than 30 years of practice, I have learned that when the public is allowed to hear about these proceedings, the public can be extraordinarily helpful to the defendant, particularly in a case like this one. Sources of information from the most unpredictable venues come to the attention of the defense. And if this transcript were to be made public, we can expect people to come and call us and tell us about information they may have which we do not now have. And part of the reason for a public trial is so that, because the proceeding is not held in secret, the public can participate through the defense and indeed through the prosecution as well, if there is information that they would want to have made available to them. So our request is that the entire proceeding be made public. If Your Honor feels that there is any particular juror, and I think, Your Honor, and perhaps we have a disagreement here, and this is a hard disagreement to moot in public, we believe that there's only one juror who has any arguable privacy interest in this case, and that all the other jurors were in fact dismissed for non-traditional reasons. Your Honor may have a different view of that. That is something that we can't debate without getting into the specifics of the transcript. I've read the transcript. You were obviously there, and I would love to argue with you about this now, but I can't because we can't reveal this in public. We are denied the ability to make some of our case precisely because this has been closed to public discussion. And so we assert an independent right. We assert a right separate from the right of the press. We assert a defendant's Sixth Amendment right to have this material disclosed so that it may aid in his defense, so that he may be given the opportunity to supplement the arguments that we made last week and arguments that we may have to make at some future time relating to the fairness of this trial and the correctness of Your Honor's rulings and the actions of the prosecution in leading to some of the challenges at issue here. As Your Honor notices, I am skirting around issues, and that's a difficulty that we have when we publicly argue about a matter that's subject to seal. But Your Honor knows what I'm talking about. I hope I know what I'm talking about. And the problem is that nobody else can be fully advised as to what we're talking about. And Your Honor, that's precisely the problem. Thank you.
All right. Thank you, counsel. Ms. Lewis?
Your Honor, may I just be heard one moment? I am here for Ms. Florio Bunton. My name is Rex Reeves, appearing on behalf of Ms. Florio Bunton.
Right. Good afternoon, counsel.
Thank you, Your Honor. Ms. Florio Bunton strongly supports the application to have the transcripts unsealed, and hers is a case study in the very concerns that the court was speaking to earlier. Ms. Florio Bunton has not made tremendous efforts to make herself available to the press, although she has spoken to the press. She's tried to maintain some semblance of a normal life, although the press has been camped out at her house continuously since her dismissal, and she's tried to address some of the questions of the press. However, there has continued to be this tremendous amount of speculation that Mr. Mirell spoke to about the reasons for Ms. Florio-Bunton's dismissal from the jury in this case. This speculation has ranged from whether she had a book deal, to whether her husband had met with a literary agent, to whether she was hitting other jurors or trying to trip jurors, or even allegations that she's just plain a racist. These allegations are utterly and totally false and, in fact, slanderous. One of the bases, apparently, it's unclear what the basis, Ms. Florio-Bunton doesn't know the basis for her dismissal, but one of the bases apparently was a letter that has been discussed in court, I believe, last Friday, the source of which is apparently contested. As part of unsealing the transcripts in this case, Ms. Florio-Bunton requests that any documents upon which the court has based any decision to dismiss any jurors, and in particular Ms. Florio-Bunton, that any such documents and any such letter that's been brought to the court's attention also be released to the public. Ms. Florio-Bunton believes that she was in fact sabotaged in an effort to get her off the jury by unknown persons, and the only way we'll be able to fully explore this, and the public will be able to fully explore this, and the only way Ms. Florio-Bunton will be able to try to find out why she was in fact dismissed from the jury or possibly targeted for dismissal from the jury is to not only obtain the transcripts but also obtain this mysterious letter or any other documents that the court may have come into possession of in the course of its investigation or interrogation of jurors in this case. And to the extent that the court is concerned about any kind of privacy rights, I cannot speak for any jurors other than Ms. Florio-Bunton, but Ms. Florio-Bunton certainly waives any privacy rights that she may have in connection with the transcripts of the proceedings. In short, Your Honor, we concur that the public has a right to know. We certainly believe Ms. Florio-Bunton has a right to know why she was dismissed after giving up 5 months of her life in this case. She wants to be vindicated. She believes she will be vindicated, and that the release of these transcripts and the release of any documentation upon which the court based its decision will be a necessary first step in achieving that vindication.
Thank you, counsel.
Thank you, Your Honor.
Ms. Lewis.
Your Honor, the prosecution is in a, not quite between a rock and a hard place, but in a difficult position. If we had our druthers, I suspect that we would like to have these transcripts all unsealed. And I say that only in terms of our druthers being those that our very limited self-interest would protect, to show that Ms. Clark's done nothing wrong, Mr. Darden's done nothing wrong, no DA investigator has done anything wrong. But, Judge, we have to look at the overall larger picture here. This feeding frenzy is a phrase that was used a few minutes ago, and as the court is well aware, and everyone else, that's what this entire case has been about. And from the beginning, from the 13th of June on through to the present date, in terms of the extreme and really unwarranted press interest in this case. Now, the reason why I cited the Fagan case to the court, and apparently Mr. Dershowitz has not had an opportunity to read it, because it does address the defendant's Sixth Amendment right to an open trial. And it does hold in this particular case, which happens to be Second District of the Court of Appeal, that the defendant in that case waived the right, if there was any, to have the public participate in that aspect of trial because it consented to the procedure initially. The facts are very similar to this case, in that case, the defense initially agreed to the in-camera procedure, and it was only after several jurors were questioned that the defense suddenly took umbrage and wanted to have them open, wanted to have the defendant present. This case holds that the defendant had no right to be present under those circumstances, having waived it initially. It also holds that the defendant had no Sixth Amendment right to access by the public with regard to the juror misconduct, or juror removal, I should say, issues. It also held, our Second District did, that even assuming the Sixth Amendment public trial guarantees applied to the juror removal proceedings, and it says that we don't think they did, but even if they did, the presumption of openness is rebutted by showing that exclusion of the public was necessary to protect some higher values, such as the defendant's right to a fair trial, or the government's interest in preserving the confidentiality of the proceedings. I interpret that, Your Honor, as our obligation to the people of the state of California to help do what we can to preserve the integrity of these proceedings. This court, during the jury selection process, which seems like years ago now, but several months ago, assured these jurors that it would do what it could in its power to maintain confidentiality and anonymity over the particular jurors.
How do you respond to the argument, though, that if there's been an allegation of misconduct, and if the court has found that there's sufficient misconduct to excuse that juror, that that person, by committing misconduct, and in fact, during the course of some of these proceedings, one party or the other has urged the court to have the juror dismissed, referred to the Attorney General for prosecution?
I don't think it is required of the court, nor do I think it would be a good exercise as a matter of precedent and public policy for the court to have to make that kind of factual determination juror by juror, which is what would be required. I don't think a waiver necessarily applies because not only are we talking about any particular juror, we're talking about third parties' comments with regard to things happening with those jurors. I mean, the investigation has not been in a vacuum with regard to these jurors. I mean, the court has not just talked one-on-one to particular jurors without other information available. So by even assuming that those jurors had waived that aspect, the other surrounding information has not been waived and should not be waived. I'm concerned because this may well have a chilling effect already, given the media scrutiny rather, and the media as distinguished from the public, but the media scrutiny on the jurors and the juror issues is really unwarranted, and this is likely to have a chilling effect on the public out there. The public is who we depend on in selecting our jury pool, and as the court well knows, we depend on their willing cooperation to come to court to serve. We do not have the resources to follow up and put people in jail who ignore summons to jury subpoenas, and I'm not suggesting the court should even do that, but it does have a chilling effect. This is not the only trial going on in this county, nor is it the only high publicity trial. There's another high publicity trial regarding two brothers, which is scheduled to start later this summer. Now, what this court does in this case may have a direct bearing on the ability of that court to obtain jurors and a representative cross-section of the community in that case. The jurors in this case were indeed promised that anonymity. I don't think they've waived it by the findings the court has made with regard to some of those jurors. And I think looking at the overall picture, in the scheme of things, the court owes it to the integrity of this process not to turn around and betray the trust of the jurors, whom it has promised, all of them, individually and as a group, betray that trust that the court, that they have now, that the court has instilled that in them. I mean, the court offered up this anonymity as one reason for their participation on this case, that the court would try and protect them. Well, what are all of the jurors going to think, and all of the panelists and prospective jurors out there in the community going to think if the court suddenly does an about-face and just releases that all?
But I've got jurors out there writing books about this. It's hardly a privacy interest worth protecting, wouldn't you say?
Well, Your Honor, with regard to some...
we've got jurors running around in limousines to talk shows. Hardly a privacy interest.
I am suggesting further than the privacy interest of those particular jurors who may be, writing a book despite not having indicated any intention to do so, at least overtly and openly and candidly, to the court or counsel during the voir dire process. I'm concerned about
the public's entitled to know the unusual currents that are swirling in amongst the jury panel here? Wouldn't you agree that this has been an atypical case regarding the voir dire process and who's willing to serve on this case?
Well, it has been atypical, but I'm asking the court to ensure that it does not get even further.
Weren't you surprised when we asked people, are you willing to be sequestered for 6 or 8 months, and we had volunteers? Didn't that mildly surprise you?
It is clear to me personally, I'll speak only for myself, that many of these prospective panel had hidden agendas, and that was certainly a fear going into this case. We didn't anticipate, however, that it would result in an avalanche of volunteers, virtually. I'm exaggerating, but, and so many people wanting on the jury. I'm tempted to mention the issue that the defense blew out of proportion on an offhand comment with regard to polygraphing jurors. I mean, Your Honor, there's nothing the court could have done more than it already did in trying to ensure the integrity of the individual jurors who were eventually selected. But my concern is for the process and its perception. We know that an overwhelming number of people out there, they're already perhaps not very high perception of the criminal justice system has already been impaired by many aspects of this trial. And this feeding frenzy by the press is only to the derogation of the rights and the interest in the public, the interest in the people of the state of California, in seeing that the people have a fair trial, and seeing that the man accused of a double murder has a fair trial. And the Figgin case does go directly to the defendant's inability at this stage of the proceedings to require the court to release those transcripts.
All right, thank you, counsel. Madam Reporter, how are you doing? All right. Mr. Mirell, any brief response?
Very brief, Your Honor. There are just a couple of points that I wanted to raise. The Friday hearing last week, as our supplemental memorandum makes clear, and I'm not going to belabor the point, there are bona fide disputes. We've just seen one here in court about the court's belief that there are 2 jurors who were dismissed for traditional reasons, and Mr. Dershowitz's view that there's only 1.
Well, I was there. He wasn't.
I appreciate that, Your Honor. And perhaps because you were there and because you contemporaneously heard what went on, we would be able to resolve this dispute rather quickly if the public and the press were given the opportunity to read what transpired where you were there. Now, they may agree with Mr. Dershowitz, who says he's read the transcripts after doing that. But in terms of the basic notion of the public's confidence in the integrity of this court's decision-making processes, and in the confidence that it has to have, particularly in light of the pending motion that the defense has filed, claiming that the prosecution is targeting jurors for dismissal, a motion which if it's bona fide, if it's true, is outrageous. It would be outrageous for the prosecution to be doing that. But whether or not that's happening, and the integrity and confidence that the public has to have in the court's ultimate determination upon the bona fides of that motion is integrally interlinked, I submit, to the disclosure of the transcripts of what actually went on. I submit that it's impossible for anyone, any member of the public or the press, to have confidence in the decision-making process of the court if the transcripts are not released, both in the context of the dismissals initially and in the context of the ruling on the pending defense motion that was argued here last Friday. Your Honor, I think the court had it right, precisely right, when on April the 12th, it conducted the post-dismissal interview of Jeanette Harris. And at the end of that interview, Sheriff's Department Commander Patrick Holland objected, as the court may recall, to the release of the transcript of that interview. And this is what you said, this is what the court said in response. The court said, this is a public court, this is a public inquiry. Because of the nature, I decided to make it a closed hearing, closed to the press, closed to the public for purposes of taking the testimony here today. But I'm under extreme pressure to make this transcript public, and I frankly don't see any compelling reason not to make it public at this point, close quote. And the transcript was duly released the following morning. That, we submit, is an archetype of the practice that should have been followed up until now. But since one ought not to reject wisdom merely because it comes late, in the words of the late Justice Felix Frankfurter, I would suggest to the court that there is a way of undoing the damage that has been done and a way of resurrecting the reputations of the jurors who have been dismissed and who may have been, and whose reputations may be being besmirched by the wave of rumor and speculation that has flooded the airwaves and has flooded the print media. And that's by releasing the transcripts now of those jurors of the dismissals of those jurors. And I do want to join Mr. Reeves' comment that to the extent that there are other evidentiary matters, I have no idea what they may be. The court last Friday said there was no letter with respect to the alleged anonymous letter from a literary agent concerning Ms. Florio Bunton's.
I don't think that's what I said.
No, that's what the official, or that's what both the unofficial and the semi-official versions of the transcript say. But I was actually confused, and
I may have said that wasn't the reason.
Okay, well, the transcript currently reads there was no letter, so the court ought to take a look at that. But in any event, what's clear is that there is a divergence of view on that question between the court, perhaps on the one hand, the defense on the other hand, which Mr. Cochran said there was no anonymous letter that his office received, and the prosecution. Ms. Clark said there was an anonymous letter, and we have phone logs, too. All of those are issues
We're speaking about three different things then.
well, okay, that may well be, but that's probably my fault. But it's my fault only because the transcripts haven't been released, and we don't know precisely what's going on here. And there really isn't a good reason why we don't. I think the question of what the prosecution's obligation is, I think the prosecution's obligation is clear, and I'm surprised and I'm disheartened that they've not joined this motion, because I think they could have had their druthers, and I think they should have had their druthers and should have joined the motion, because there is a constitutional right in the state of California under the Crime Victims Justice Reform Act of 1990. There is now a public right to a public trial. That's a right held by the people of the state of California. That's who the prosecution represents. Article 1, Section 29 of our state constitution says that that's a right that ought to be taken into account. And I heard nowhere in Ms. Lewis's argument any acknowledgement that that occurs. But what I did hear is a claim that, well, maybe jurors are somehow going to be chilled. But I think there are a couple of responses to that. One was the response that Your Honor gave, that this is in fact an atypical case, and that no one, not legislators in Sacramento, not members of the County Board of Supervisors across the street, ought to be taking the Simpson case as an archetype of anything. This is sui generis, and if the case were possible to throw into a legal dictionary definition, I think this would be it. This is not the case from which to extrapolate rules of general applicability. This is a case that breaks the mold in many, many, many ways. And I think the public is smart enough to understand that, and to understand that this is an extraordinary case in which people are doing extraordinary things. Jury consultants tell us that jurors don't want to be sequestered. Yet here we have jurors who volunteered to be sequestered. We have a situation, though, Your Honor, where by failing to disclose these transcripts, what we may be chilling is something that's much more important. We may be chilling the fact that jurors, the public's notion, the public's understanding that jurors are engaging in misconduct. And I think one of the things that we do affirmatively want to chill, Your Honor, if anything else, is juror misconduct. And I think to the extent that the public understands why it is that jurors are being dismissed, if it's 10 or 11 of the jurors who are being dismissed for misconduct reasons, the public has a bona fide reason and a right to know why that's occurring. And I think the court can easily satisfy that concern, and in doing so, serve other interests as well. Serve the court's own interest in ensuring the integrity of the system, serving the public's interest in the integrity and the fairness of these specific proceedings, and in any verdict that may ultimately be passed upon by these jurors. And it also serves the interests of the jurors themselves, because it is they who have had to bear the brunt of responding to what may be inflammatory and irresponsible and reckless allegations made about the reasons for their dismissal. That would all be remedied. Those problems would vanish once these transcripts are released, and this would be a non-issue, and the court would not have to see me again on this issue. And I appreciate again the court's indulgence.
On this issue.
Your Honor, just
I reserve rights, Your Honor.
1 minute, if I may, Your Honor.
Certainly.
We believe the Fagan case supports our position. I have read the Fagan case within the time it was given to me and now, and indeed that raises a different problem. We don't think the prosecution should be allowed to come in here, having had a case, knowing what their position is, and simply state to the court on the day of the argument, this is our position, this is our case. Talk about reciprocal discovery. That's just not fair. If they have a case, if they have a position, we have the right to know it in advance. We have a right to think about our response to it. We have a right to work out our response to it. We have a right to search and shepherdize cases, and they have no right to blindside us this way.
Well, Mr. Dershowitz, you filed a response to the motion, citing cases and authorities. Prosecution chose not to even do that. What does that tell a court? So maybe you're all wound up about nothing.
Well, no, you may be right, Your Honor. It tells us that the court believes that the government's position is at least ambivalent or
Well,
not.
if the prosecution chooses not to even respond in writing,
Well, we accept that. And the reason the Fagan case supports us is because in Fagan, the issue was simply whether or
Counsel,
not.
I've read the Fagan case.
Right,
I'm familiar with Judge Branlin,
right.
Justice Facuto, Justice Boren.
In light of Your Honor's statements, I think I have nothing further to say.
All right, thank you.
Your Honor, before you say anything more in light of the court statements, I want to let the court know that we are very seriously opposing the release of these transcripts for the reasons which I've revealed. Please do not take our failure to file a brief as any indication that we're not. In addition, when the court first called us for hearing, I stood up and said their response was untimely, the ACLU supplemental brief was untimely. We're willing to waive untimeliness if they're willing to waive the citing of this case. I don't know what we're bickering about with regard to that now. But the point is, Your Honor,
Well, no, Mr. Dershowitz indicated he had reasonable opportunity to read it. He's argued it.
I want to ensure that the court is satisfied that the prosecution feels the court has had good cause all along to maintain the confidentiality of those proceedings which resulted in the sealed transcripts, that as a matter both with this particular case and for public policy reasons for future cases, the court should maintain that confidentiality. And I want to make the final and what is fairly obvious point that the defendant is having a very, very public trial. And the court has been very generous in allowing the cameras to remain in the courtroom throughout these entire proceedings. We are talking about a very small portion of an otherwise very, very public trial. And it does not, just because the press wants to know this information does not mean it's in the best interest of the public when you weigh all of the concerns of the public to release it.
Thank you, counsel. Well, I think this is a situation where we'll let the public decide what's in the best interest of the public. The court will undertake to redact the personal identifying information of the jurors involved, and so counsel are aware the court did on many of these circumstances independently on its own motion call witnesses, examine witnesses during the course of these proceedings. Court will redact from the transcripts names and places of employment, other identifying information. There are several hundred pages of these transcripts in several volumes, perhaps dozens of volumes, maybe 30 volumes of proceedings that the court has conducted with regards to these. So they will not be immediately available. You should anticipate release of these transcripts close of business July 3rd. That should be sufficient time.
Your Honor, may I just ask one question?
Certainly,
What about
counsel.
the underlying documents and things like that that may have
I'll
come
make
up
that
in-
available.
Excuse me?
I'll make that available.
Thank you, Your Honor.
All right. There's an old Chinese saying, be careful of what you wish for. Thank you.